African Americans have and continue to undergo discrimination. Despite the laws implemented and the struggles many people face to fight against segregation and gain equality, African Americans still have not obtained complete, fair, and equal treatments. Back then, laws were put in place to segregate blacks and whites. One in particular was a separate but equal law, which was implemented through the outcome of the Plessy v. Ferguson case. During the 1950s, the well-known case, Brown v. Board of Education, fought for equal opportunities for children in the school systems. This case was a combination of 5 very similar cases: Brown v. Board of Education of Topeka, Briggs v. Elliott, Davis v. Board of Education of Prince Edward County, Bowling v. Sharp, and Belton v. Gebhardt. In Brown v. Board of Education of Topeka, Linda Brown's father, Oliver L. Brown, sued the board after they refused to allow his daughter to attend the all-white school 6 blocks away from her house. Linda Brown, a 3rd grader, had to walk 6 blocks to her bus stop, which would then transport her to the all-black school a mile away. The issue presented in front of the court was whether or not separate but equal laws in public schools were unconstitutional and denied black children their rights under the Equal Protection Clause. Thurgood Marshall, a member of the National Association for the Advancement of Colored People, also known as the NAACP, took on this case. He argued that this law was a violation of African Americans' rights and it undoubtedly segregated and discriminated against them. Furthermore, this law resulted in insecurities and low self-esteem among African American children, along with the poor education system. In Briggs v. Elliott, African American students had to walk as long as 8 miles to school due to unequal transportation. African American students were not given bus transportation because school officials stated that it would be unfair for white taxpayers to pay for transportation for black students if their community did not pay enough taxes. In 1948, the county board was first sued in federal district court, however the case was dismissed. Finally, in May 1950, Briggs v. Elliott was filed, and the focus changed from fighting for equal transportation to fighting for segregation. The decision of this court ruled that the schools should be equal, however not integrated. With this ruling, the case then appealed to the Supreme Court, where it was then combined with the 4 other similar cases. Davis v. Board of Education of Prince Edward County surrounded the poor conditions of an all-black high school, R.B. Morton High School. The school's capacity was 180 students, however 450 students attended that school. Also, the black students throughout the county were constructed out of wood. They were only supplied wood, coal, and kerosene stoves to generate heat, and there weren't any indoor restrooms. The property value of the schools were also only $329,000. In comparison to the black schools, the white schools were constructed out of strong brick, they had hot water and heat, and they also had indoor restrooms. The property value for these schools were $1.2 million. When brought to the district court, the courts ruled that the schools were unequal and should be changed to meet the expectations of the separate but equal law. After this decision, the NAACP appealed to the Supreme Court, and Davis v. Board of Education of Prince Edward County became a part of the Brown v. Board of Education case. Bowling v. Sharp was very similar to the case Davis v. Board of Education of Prince Edward County. In this case, the black schools were also in poor conditions, and they were not suited for children to attend. However, despite the bad conditions, black children by law were not allowed to attend the all-white school, John Philip Salsa Junior High School. The NAACP sued the board in the district court. However, the district court dismissed the case, so the NAACP appealed to the Supreme Court. The last case was a combination of 2 cases, Belton v. Gebhardt and Bula v. Gebhardt. In both cases, parents fought for their children to obtain equal treatment within the education system. In Belton v. Gebhardt, Belton and other parents who lived in Claymont, a nice suburban town, could not send their children to Claymont schools because they were only open to white children. After being denied by the state education officials, the parents, with the help of attorney Louis Redding, appealed to the Supreme Court. In the second case, Sarah Bula experienced similar issues and unfair treatment as the parents of Claymont did. Bula had to travel miles in order to drop her daughter off at a poor, rundown school. These two cases were appealed to the Supreme Court and then placed under the case Brown v. Board of Education. Under Chief Justice Warren, the court struck down the separate but equal law in public schools with a 9-0 vote. He stated that this law was unconstitutional and violated the Equal Protection Clause guaranteed by the 14th Amendment. Warren agreed that this law was a legal form of discrimination and segregated schools negatively impacted African American children. Brown v. Board of Education, along with many other cases, became stepping stones for the Civil Rights Movement, which ultimately gave African Americans more freedom and fair treatment in the law and in society.